This is April 27, 2012. We're at the Justice Building. I just had a hearing, and I'm going to talk to some people who saw the hearing and get some responses. How are you doing today?
I'm doing very well.
And what's your name, Sally?
Sally Brooks.
All right, and you were watching a hearing today?
Yes, I was. I was watching a hearing between Andre Murray and various other parties, all represented by lawyers. And I would, if it was the first time I'd experienced something like that, I would have said I was profoundly shocked. But I'm now seeing firsthand again and again and again that there is no justice in New Brunswick courts. The judges are biased, hypocritical, and show preferential treatment to lawyers. The self-represented Andre Murray presented an extremely solid, very well argued case. The other parties had nothing to say, and the judge ruled in their favour every way. She spoke in a very rude tone of voice to Andre. She spoke in an entirely different tone of voice to the lawyers. She accepted hearsay evidence from them and made decisions from that, and she didn't accept actual facts from Mr. Murray. She refused to hear a recusal motion for her to remove herself from the proceedings because of her behaviour. She refused to hear it until the first motion was heard, said she couldn't recuse herself until it was heard, which is actually not even the truth, because the rules of court say when a judge only hears part of a case, she's replaced by another judge. So she wasn't even telling the story like it says in the Judicature Act.
Yes.
When the first motion was heard, she then said to Mr. Murray, "Am I correct in that you actually want me to recuse myself from all of your proceedings?" To which the answer was yes. And that confirms she knew she should not have heard one single issue today until that recusal motion was dealt with. I am disgusted. I continue to be shocked. And I hope there will be a public inquiry one day soon into the injustice in the courts of New Brunswick.
So there does appear to be differential treatment towards self-represented litigants compared to a lawyer who's representing a party.
Absolutely. As a self-represented litigant, you're required to know all the rules, you're required to know all the law. There is no grace given to compensate for the fact that we're not lawyers, we're not trained, we have no legal education. There is no leeway, and even the rules of court state that people who are self-represented should be accommodated because of that. And the whole point of court is for the most timely, just and cost-effective resolution, which is not happening because they're taking advantage of self-represented parties.
What's interesting as well is that the Chief Justice Drapeau has actually stated on the record that a self-represented litigant who has actually shown that they've spent a lot of time and energy and effort into providing a well-researched, well-presented document, as in preparing for court and providing all the briefs and submissions and everything necessary, should be provided costs when they're successful. And what's interesting is that people need to understand the monumental task it takes to actually prepare standard paperwork that a lawyer does every day, day in, day out. They pull the blank form off the shelf and just fill in the blanks like they've done day in and day out. And for a self-represented individual to do that, they have the monumental task of learning all the rules of court, getting the correct forms, fill them all in, and then get that stuff in.
Yes.
And it seems like the judges are very reluctant to award or even to take into consideration the amount of work that a self-represented litigant does.
They're not only reluctant, they are absolutely hostile to it because they do not want to set any precedent. And I believe that Justice Drapeau only made that comment because it was probably a Court of Appeal hearing or something like that where he was forced to say it. But they do not abide by it and they do not respect it.
Okay.
Shame on them.
Yes. It seems like it's difficult to get justice in the halls of justice when justice is defined by Black's Law Dictionary as a fair application of laws. And all the rules of court are actually touted by various judges to be, the interest of justice, that the law should be applied where necessary to see that justice is done, and people should not be You know, people should not be barred from their day in court by mere little technicalities and such. And
that's right.
That's not the spirit of the law.
That's right. And that's not the way it's even written. It's written to allow for errors, to allow for accommodation, where justice is the important thing, not the technicalities. But that's not what we're seeing. It's any excuse to shut down a self-represented party's case, particularly when it's a solid case and particularly when it's exposing wrongdoing by members of the establishment.
Was there anyone notable that you saw in the courtroom today?
Oh, I saw lots of people in court today. Mayor of Moncton City, George LeBlanc, Lou Cameron from Stuart and Kelby, who I'm now learning about in a not very nice way. Both those. The clerk of the court dropped in for a visit. There was a journalist there for a short while, and numerous other parties observing. It was like being at a wedding where everyone was on one side, and it wasn't on the side of the self-represented litigants.
Yes. All right. And was the Attorney General represented today?
Supposedly, but nobody stepped forward to identify that they were the Attorney General's representative. And I believe that's because they've asked for an adjournment. If she had a representative there, they certainly didn't say anything. And I suspect it was already planned and organised that that would not be heard, so they didn't even probably turn up.
Okay. And all right, any final comments on the hearing?
Well done, Andre, because you presented fantastically. You gave your argument, you covered everything. There was no grounds for anything you presented to be refused, because you presented the case, the argument, the supporting law, and the facts. And that judge came in, Justice Clendening, to deny. And I would like to note in closing, she didn't make a single note when you were speaking, but she wrote down everything the lawyers said when they were speaking. When she made her decision after the first motion, she took a few minutes recess, and she came back with about 4 or 5 pages, which she had obviously already written out to refuse you. So I don't think it made any difference what you said today.
Okay, thank you for that.
Pleasure.
This is Fredericton, New Brunswick. We're at the Justice Building, having just been at a hearing. So have a great day, everyone. Thank you for watching.